Hi, this is Matthew Brickman with iMediate Inc. I wanted to bring this to you immediately as today, June 26th, the United States Supreme Court has struck down the bans on same-sex marriage in a historic 5-4 ruling. The justices ruled that states cannot deny gay men and women the same marriage rights enjoyed for thousands of years by opposite-sex couples. For far too long, some states have recognized gay marriage while others have not. So what is the gay couple with a child or two lesbians who have purchased property together supposed to do when it ends? I am excited that now there is equal protection under the law in all 50 states.
As of January 6th, 2015, thanks to a case called Brenner versus Scott, same-sex marriage is now legally recognized in the state of Florida.
So what does this mean in the state of Florida? Well, what this means is that now, unlike prior to today, the gay and lesbian community and transgender can now get married, but that also means that they can also get divorced as well.
Law, previously, it could not exist because they had ruled that it was unconstitutional. So that left a lot of couples that were in same-sex marriages in this state of unknown.
I received a phone call from a law firm that was looking for a mediator to do a same-sex divorce, and I said sure. They scheduled it, and the next day called back and canceled it. None of the judges, none of the 10 family court judges in the 15th Judicial Circuit, which is Palm Beach County, would be signing off on any same-sex divorces until the Supreme Court rules later this year. And in Palm Beach County, they are performing same-sex marriages, but now they will not sign off on the divorce. So it's a lot like Hotel California for our same-sex marriage friends that can now check in any time they'd like, but they cannot leave. Another issue is trying to define a marriage or define the relationship, and when did it become a legitimate relationship for acquiring property or even having a child? Was the child born of the marriage? Well, that's pretty easy when you're dealing with a heterosexual couple, but with a couple from the same-sex marriage, that's going to be difficult because they weren't allowed. So then we go back, and some states had civil unions and some states did have marriage, and so now it's a matter of looking and defining, okay, well, do we go back to when there was a domestic partnership? Was it a civil union? Was it an actual marriage? And was the child or the property acquired during that boundary? And what boundary are we going to use? These are just some of the many issues that are facing the legal community. Another issue is going to be alimony, because how do you define a supportive relationship? Well, with heterosexual couples, that's simple. They were married. But when you've got same-sex couples that were not allowed to marry, when did they become a dependent spouse? When were they reliant on the other spouse? Now, a same-sex couple who gets married, accumulates assets and debt, has children, and eventually gets divorced will find the same protection under the law as the heterosexual couple in family. iMediate Inc. is here to assist every couple as they transition to the next phase of their life in a peaceful, inexpensive, and expeditious manner as to preserve the family unit in a divorce, regardless of their sexual preference. And we look forward to assisting all of those needing our services in the future, regardless of their sexual preferences and orientation. It's a historic day in the United States, and iMediate is here to congratulate all of you, and we look forward to helping you transition your lives in a peaceful, inexpensive, and expeditious manner from this day forward. For more information on having your mediation conducted by iMediate Inc., contact me at iChatMediation.com, toll free at 877-822-1479, or local 561-262-9121, and I look forward to mediating for you and your family.